Welcome to Overheard, the Foreign Policy Research Institute's new podcast series exploring the national security implications of intelligence activities, irregular warfare, and political warfare. Join Philip Wasielewski, Director of FPRI's Center for the Study of Intelligence and Non-Traditional Warfare, as he discusses the past, present, and future of these activities with intelligence, military, and political practitioners to discover what is new at the intersection between the craft of intelligence and the military and political arts. New episodes are available each month on Apple Podcasts, Spotify, or wherever you get your podcasts.
Hello, and welcome to the inaugural podcast for the Foreign Policy Research Institute's Center for the Study of Intelligence and Non-Traditional Warfare. My name is Phil Wasielewski. I'm the center's director, and I will be moderating the discussion between two legal experts about the ongoing debate about the renewal by Congress of Section 702 of the Foreign Intelligence Surveillance Act. This provision of the Foreign Intelligence Surveillance Act, also known as FISA, allows U.S. intelligence agencies to collect foreign intelligence information from the communications of foreign terrorists and foreign countries as those communications flow through America's telecommunications infrastructure. Allowing it to expire, in the opinion of the President's Intelligence Advisory Board, would be, quote, one of the worst intelligence failures of our time. However, there are those in Congress on both the left and the right of the aisle who do not wish to see it renewed. Joining me to discuss this issue is another FPRI senior fellow, George Croner, who recently published an article on FPRI's website titled, "A Key U.S. Intelligence Tool is Set to Expire." George is a Naval Academy graduate and a graduate of the University of Pennsylvania Law School. A former attorney at the National Security Agency, NSA, he had legal oversight responsibility for NSA's signals intelligence operations, including FISA compliance. During the same period, George also served as NSA's principal litigation counsel and represented NSA's interest in a variety of legal matters regarding its operations. George has had extensive private practice experience since leaving NSA and also serves on the advisory council for the University of Pennsylvania's Center for Ethics and Rule of Law. Also joining our discussion is Kristi Scott, who formerly served as the Privacy and Civil Liberties Officer at the Central Intelligence Agency. In this role, Kristi served as an independent primary advisor to the CIA director to ensure that privacy and civil liberties are integrated into the day-to-day conduct of the agency's mission. In this capacity, she oversaw the Office of Privacy and Civil Liberties at CIA that is charged with the oversight of protecting U.S. person information at the agency. Kristi also served as the acting director and deputy director at the U.S. Department of Justice's Office of Privacy and Civil Liberties. During her long service at DOJ, she also was an assistant United States attorney. Kristi Scott graduated from the University of Pittsburgh and Pennsylvania State University's Dickinson School of Law. She is speaking with us today in a private capacity while on leave from CIA. So I welcome both of our guests, and I'm going to start the discussion by turning to George Croner and asking him to please tell us just what exactly is FISA Section 702, how it came about, and how it works. George?
Thanks, Phil. Thanks for that generous introduction and for having me on the podcast. This question is one that I could take the rest of the podcast if I wanted to try and explain it all, but I'll try and give a thumbnail sketch. FISA, the Foreign Intelligence Surveillance Act, was passed in 1978. In the 22 years that elapsed between then and 2000, a significant number of technological changes took place in how the worldwide communications network operated. Principal among those were the enormous growths in email and cellular telephone, communications. When the attacks occurred on 9/11, it was realized that an enormous amount of traffic was flowing through via largely email through US servers on US soil. But FISA, as it was then written, termed those communications electronic surveillance requiring FISA court orders. So that, for example, if you had a foreign terrorist abroad sending emails to another foreign terrorist abroad, and those emails flowed through U.S. servers on U.S. soil, you could not acquire that information without a court order. And given the speed and flexibility necessary, obviously, especially in the aftermath of 9/11, that proved exceptionally cumbersome. So the Bush administration took it upon itself to institute a top secret program called Stellar Wind, in which it authorized the national security to begin intercepting those communications. So Stellar Wind basically authorized the interception of communications that FISA prohibited without a court order, and NSA was doing it without a court order. Program was very highly regulated internally, highly classified, went on for a number of years until it was disclosed by the New York Times in December 2005. There was a firestorm, as you might imagine, about the fact that the Bush administration was allowing this to occur, even though it violated FISA. And remember, among the important points here is that FISA has always contemplated that while foreign targets are obviously the sine qua non of FISA surveillance, an agent of a foreign power or a foreign power, the statute has always contemplated that the U.S. persons who communicate with FISA targets, their communications could be incidentally collected and stored and handled by the U.S. government. And now you had a situation where the U.S. government was collecting communications on U.S. soil without a warrant, or a court order, I should say, in violation of Title I of FISA. And obviously there were incidental U.S. person communications involved. So between 2005 and 2008, a number of temporary measures were taken to keep the program going, none of which was a perfect fit. But in 2008, Congress authorized in the FISA Amendments Act of 2008, a new section, Section 702 of the Foreign Intelligence Surveillance Act, that contemplated that the government would now be authorized, that is, the Attorney General and the Director of National Intelligence could jointly authorize the targeting of persons reasonably believed to be located outside the United States, foreigners, to acquire foreign intelligence information for periods of up to 1 year. There were a series of proscriptions on that authority, one of which, and the most important of which, is that Section 702 can never be used to target U.S. persons inside or outside the United States. However, like FISA, Section 702 contemplates that there will be incidental collection of U.S. persons who are communicating with those foreign targets. And so, as I say, in 2008, Congress basically created a legislative framework for the type of activity that had been going on in the Stellar Wind program. And since then, unlike other provisions of FISA, which are permanent, Congress recognized that this was rather controversial, and therefore Section 702 has never been a permanent surveillance authority. It always requires reauthorization. It was reauthorized by Congress in 2012, again in 2017, and it is up for reauthorization this year. In each successive reauthorization debate, the majority or the margin by which 702 has been reauthorized has shrunk. And this year, because of some rather unusual political circumstances, which we can go in later if you want to, Phil, Section 702 is as close to not being reauthorized as it has ever been. And as a result, there is a debate in Congress right now, an intensive debate, lots of folks weighing in, and the principal issues are, again, the scope of incidental collection of U.S. person communications, because again, all of this 702 collection takes place in the United States without a court order, because the targets are foreigners who have no Fourth Amendment rights. But all of those U.S. persons have Fourth Amendment rights. And the theory of 702 is, when it was enacted by Congress, Congress requires that as part of this collection program, there have to be a series of procedures, what are called targeting procedures, minimization procedures. And in 2017, they also added querying procedures, plus what are called Attorney General guidelines. All of these procedures are designed to protect the Fourth Amendment rights of those Americans whose communications are incidentally collected. All of those procedures are reviewed by the Foreign Intelligence Surveillance Court, and they must be approved as being consistent with the Fourth Amendment, both as written and as used in practice. The FISA court just wrote its most recent opinion on 702 was in April of this year. It indeed endorsed or ratified all of the procedures being used by each of the four agencies that have access to 702 information: NSA, CIA, the National Counterterrorism Center, and the FBI. However, that hasn't satisfied critics who still believe that the program as currently constructed needs substantial overhaul, significant reforms if it's going to be reauthorized. And the principal focus of those reforms is the FBI and how the FBI conducts its work. So in a nutshell, that's sort of the evolution of how we got from FISA to Section 702 and where we stand today with 702. If I've missed anything of significance, I'm sure Kristi will add it to the conversation, but I'll stop here, Phil. If you have anything else you specifically want me to focus on, I will, but I think I should turn it back over to you.
Well, thanks, George. That's a great review of how we got here and the Fourth Amendment issues revolving around Section 702.
The United States is in the midst of a turning point as technological, political, economic, and environmental changes reshape both the global system as well as the definition of national security. In the midst of these rapid changes, how will the U.S. adapt, and what will the integration of defense and technology entail? Join us on December 13th in Philadelphia for the 17th Annual Benjamin Franklin Awards celebration. This lunchtime event will feature a discussion on the future of technology and national security with Phoebe Novakovic, the chairman and CEO of General Dynamics and this year's Benjamin Franklin Award recipient, and former National Security Advisor H.R. McMaster. Information about attendance is included in the description of this podcast and on our website, fpri.org. We hope to see you there.
Before we go to Kristi, I want to ask you now for the national security implications. What is this capability within 702, and why is it considered so vital to national security, and what are the implications if it's not renewed?
I'll start with the last first, Phil. What are the implications if it's not reviewed? Catastrophic from an intelligence perspective. This is, in my view, the most important intelligence collection program the U.S. government has. It's certainly the most important technical intelligence collection program the government has available to it. Brett Holmgren, the Assistant Secretary of State in charge of their Intelligence and Research Bureau, gave a talk a little while back, talking, for example, about things you don't necessarily think about. It's obvious how intelligence is important in defense issues, non-proliferation issues, and so on. But Holmgren spoke at length about the importance of this program in a diplomatic sense, how important it is to be able to have the Secretary of State and U.S. diplomats aware of what the Chinese are doing, what the Russians are doing, what kind of atrocities the Russians are committing in Ukraine. To not authorize this program would, in my friend Jim Petrilla and your friend Jim Petrilla's words, amount to unilateral disarmament. Section 702 information comprises 70% of what appears in the president's daily brief every day. So you're talking about eliminating that capacity. Now, I'll just finish by, so those are the consequences of failing to renew. And I'll say that even the Privacy and Civil Liberties Oversight Board, of which I'm not necessarily a particular fan, issued a report last Thursday. And in that report, which was bitterly divided amongst the minority and majority and minority members, and had a number of issues with which I take issue, all 5 of the members of the PCLOB, which exists to protect civil liberties and privacy interests of American citizens, all 5 of them said that 702 is in fact an indispensable intelligence tool and should be renewed. The question is, what sort of reforms, what sort of overhaul may be necessary to protect American citizens' rights? And I'm sure Kristi can speak more eloquently to that than certainly I can.
Well, thanks, George. Those are good questions, and that's a good way for us to transition over to Kristi. Kristi, please tell me, there's obviously another side to this, or there's at least another view of this. Why is there resistance to renewal of Section 702? And what are the opposing viewpoints regarding it as currently written?
Thanks, Phil. There is a lot of discussions, as George noted, from the Privacy and Civil Liberties Oversight Board, which was created to in the aftermath of September 11th and the corresponding statutes, to really provide a checks and balance system to the broad capabilities that the government was responsible for, but to really focus on how the government was doing that to provide both advice and oversight in those counterterrorism programs. And as part of my job at the Department of Justice and at CIA, a primary function of my job was to interact with the Privacy and Civil Liberties Oversight Board, to respond to requests for information. And I do think they provide a vital role in terms of giving a voice and providing transparency to government activities that might otherwise be classified. I think primarily, as you noted, the most significant privacy and civil liberties risks stem, as George noted, from U.S. person queries as well as batch queries, which was the subject of a great deal of debate with respect to the FBI in the annual statistical transparency report in terms of how those batch queries were run.
Could you tell us real quickly what are batch queries?
So batch queries are when there are um, eh, really groupings of queries of information, such that you don't necessarily have time, or the mission dictates that you have to run queries in groups. If there are large scale investigations, say, for example, if there is a cyber event or something that requires an analyst to continue to run a similar search, given the pace and alacrity by which the mission of the intelligence community dictates, which I know George is going to talk about, again, some of the significant impacts if 702 is not renewed. But the crux of the concern really stems on the fact that Section 702 of FISA permits the government to collect without warrant those emails, text messages, phone calls of foreigners overseas, again, even when those foreign nationals are communicating with U.S. persons. The piece of it that I think really causes privacy and civil liberties advocates, as well as civil society, to have concern is with respect to incidental collection. In plain terms, the privacy advocates see that incidental collection of U.S. persons as a backdoor search loophole to the Fourth Amendment, which protects those papers and that other sort of information that would otherwise be subject to a constitutional moment. And given some of the great advances in technology, the ability to collect just massive amounts of information that wasn't necessarily present in 1978 and even indeed in 2008, privacy and civil liberties advocates assert that the public should be able to know how to calculate, how to estimate, and really quantify how much information is being collected as a result of this incidental collection. And as George honed in on, there have been high-profile media headlines that have led to typically strange bedfellows, in the sense of both Democrats and Republicans coalescing and really finding themselves at the crosshairs for different reasons, but also really focusing on whether or not this should be authorized in a clean authorization, or the statute should be authorized with different caveats and different requirements. One of the things in terms of the congressional procedures, as well as the court review, which is an important component of this, is the Foreign Intelligence Surveillance Court, or the FISC, they review those targeting, querying, and minimization procedures. And internally, this is another point of contention with advocates. Those reviews are also reviewed by the Department of Justice as well as the Office of the Director of National Intelligence. And part of the criticism has been, can those agencies who are executive agencies police themselves as opposed to having a court provide that review? And so what we found in some of those transparency reports is that those numbers, those high numbers have served really as a lightning rod to advocates who view the number of incidental US person collection as staggering. And so even though the number of incidental US person collection is small relative to the program, and even though it is lawful, and the Privacy and Civil Liberties Oversight Board in 2014, 2015 found that it indeed was lawful, and there was great efficacy to the program, they have made 19 recommendations that they think, at least along the Democrat and Republican lines, that they think should be present in any reauthorization. And so I know that one of the things that we are going to now pivot to are, what are some of the key areas for potential congressional action, and whether or not there are pragmatic solutions that would be key for reauthorization in December of 2023.
That's exactly the area I'd like to go to. I'd like for both of you, and Kristi, I'll start with you, to talk about, although there's a viewpoint that this is a backdoor search of the Fourth Amendment, is it really? Have not other courts using the Fourth Amendment standard of reasonableness agree that this does not require a warrant? Why is that? And what would be problems of incorporating further judicial review into this process? I'll start with you, Kristi.
Yeah, I think further judicial redress, and the speed of mission is something that both you, George, and folks within the intelligence community understand, that there may be, in some cases, a series of days or hours by which information may come to the attention of the intelligence community, and courts are not necessarily known for being expeditious. And so what happens, and I think at least the minority viewpoint in the Privacy and Civil Liberties Oversight Board report really talks about a potential to go back to what was known as sort of that pre 9/11 wall, by which there were delays, by which FBI and other parts of the intelligence community, CIA, were stymied, and also, found it to be very cumbersome to have a before, and we talk about sort of ex ante and ex post facto review by the court. And so it can be cumbersome to go to the Foreign Intelligence Surveillance Court within a matter of hours, because there are papers and probable cause petitions that have to be prepared, reviewed, and also have to have the requisite amount of due diligence to make sure that those meet the standard for a federal court. I think one of the things that we have to think about in terms of the whole reason for FISA was this tension between what the president could do in his powers of, commander in chief, and his powers to engage in matters abroad, and what Congress can do in terms of being able to regulate those efforts.
Thank you, Kristi. I want to turn to George on that last part. But before I do, you said something very important that struck me, and that is about speed of mission. Now, for those listening, there's something called the Foreign Intelligence Surveillance Court, which I believe is approximately 12 judges. And I remember on the NSC staff with these issues, that about 300 cases per year, and please, both of you, correct me if I'm wrong, normally come before this court.
337 last year, Phil.
337.
337 Title I court orders last year to the 11 judges that sit on the FISC.
337 to be divided by 11. However, George, in your article for FPRI, you note that there are over 246,000 targets which can possibly bring incidental collection. Now, if each of these targets, whenever there was incidental collection, had to require a warrant, would this not overwhelm the Foreign Intelligence Surveillance Court? Because I mean, I'm good friends with a local judge here. He's always telling me about policemen are coming to his house at all times of day and night to have to get a warrant signed. It's for, these sorts of things is a matter of hours. But for this court, it's not a matter of hours. It's a matter of days, if not weeks or months for this process. Please tell us how this works and what having to do a warrant would do to the court.
I think I can narrow that scope of what you described, Phil, and make it a little more accurate with numbers that I think Kristi would be able to agree with. There are, or at least in the last statistical transparency report, over 246,000 foreign targets. But that's really not the number we're talking about here. The FBI, and let's face it, it's the FBI that we're talking about. The 702 reauthorization debate is almost entirely about the FBI. And the FBI only gets access to about 3.2% of the communications associated with those targets. So about 8,000 targets. The FBI says in the statistical transparency report that it ran about 120,000 US person queries last year. It says it gets hits. The PCLOB report indicated that it gets hits on about 2% of those. So the number is smaller. It's 24. Let's say roughly 2,400 US person queries a year would be affected by this PCLOB court order requirement. Now, that may not sound like much, but as I said, the FISC in its entirety generated 317 Title I court orders last year. 2,400 more requests for court orders essentially amounts to 6 per day. They do not have the judicial resources or the time to handle that workload, which is why I have said in other articles that I've written that if you're going to require a court order for US person queries in connection with 702, let's be honest, as a practical matter, you are eliminating US person queries as an intelligence tool with that particular program. There is no way the FISC can accommodate that kind of review posture unless you're going to expand it to 25 or 30 judges. And even so, as you point out, Phil, every one of those Title I orders is carefully analyzed and reviewed. They don't take place in 24 hours or 48 hours or even a week. Literally, you write an application, you send it to the court, they send it back to you with their comments. The Justice Department plays with it a little more. It goes back to the court, and then maybe finally it gets approved. If you want if you want 702 and the use of US person queries to have the speed and flexibility that policymakers expect and have come to anticipate from 702 information, that kind of court order querying requirement, at least with respect to US persons, would eliminate US person queries as a viable source of intelligence.
As we come towards the end of our podcast, I'd like to ask you both to kind of summarize the risk versus gains of renewing 702 for our listeners. And Kristi, I'll start with you. What are the risks to civil liberties, to Fourth Amendment protections, vices, the gains for national security in this renewal debate?
Thanks, Phil. I think from what I've seen, and again, I have a different optic, having spent nearly 2 decades in both law enforcement as well as in the intelligence community. What I've seen is that 702 FISA collection programs are the most regulated, scrutinized, and carefully enacted programs, I think, in the world, and certainly in any democratic society. I think that in terms of a risk benefit calculus, I think that the risk of not reauthorizing FISA would have, again, catastrophic consequences to the security, safety of the United States as well as its allies. I do think that there are common sense solutions and pragmatic um, pieces that could be incorporated in any piece of legislation that would mitigate those potential risks to U.S. persons. And I do think that there are adequate safeguards. Certainly, we've seen reforms over the last couple of years, whether that be additional training, whether it be different types of audit mechanisms by which you have this iterative process by which you can discover and uncover compliance incidents. Let's face it, if you aren't finding compliance incidents, that's a sign of a faulty program, right? Because if you're not finding the problems that you're looking for, it's not an effective program. So I do think that there are legitimate concerns articulated by the U.S. Constitution in terms of case law, and civil society advocates have certainly made a strong case for additional safeguards that would instill the sort of trust and confidence in the program while allowing it to continue to protect the United States and making sure that we do not return back to that pre 9/11 posture.
Thank you very much, Kristi. George?
Well, I certainly agree with Kristi on the risks of not reauthorizing 702. That's a non-starter from an intelligence perspective and from a national security perspective. As far as privacy and civil liberties, the FBI has stumbled badly from the creation of the querying requirement in 2017 to get its house in order. The FISC has documented the FBI's missteps in a series of opinions. It's not a coincidence to me that in the middle of 2021, the FBI began instituting a long series of reforms that were designed to improve their querying performance. And the FISC has acknowledged that those reforms seem to be taking effect and their improvements seem to be occurring. The question is whether Congress will be patient in the sense of allowing those reforms to continue to implement themselves in a way that convinces everyone that the FBI is acting properly under 702. My guess is Congress will not be patient. There will be reforms instituted, principally directed at how the FBI handles itself and handles its querying process. Now, whether and what restrictions that involves, my only suggestion to Congress would be, because I think the bugaboo here is the FBI is the only agency that has access to 702 materials that has both a law enforcement and foreign intelligence or counterintelligence mission. And that law enforcement mission is what, as Kristi described earlier, creates this backdoor search issue. But it's Congress that created this. They're the ones that allow 702 and all FISA information to be used as evidence of crime. They wrote it into the minimization procedures back in 1978. They're the ones that, when they adopted the querying procedures, said, you know what, the FBI can still query in the assessment stage and before they make a predicated investigation. So if Congress wants to change that, they can. And my guess is there will be measures taken to somehow rein in or put boundaries around how the FBI can query, certainly at least with respect to evidence of crime queries, which currently FISA and Section 702 permit. But that's, to me, that the outcome that would be best for the country here is to renew this authority, as I say, but implement the types of additional safeguards and reforms, many of which are contained in the 19 recommendations that Kristi mentioned, the PCLOB as putting forward in its report.
Well, thank you, George. And unfortunately, we've come to the end of our time. I'm sure if we had an hour and a half for the podcast, we'd still have much more that we would like to cover. I'd like to thank both of our guests, George Croner and Kristi Scott, for an excellent presentation of both sides of this complicated and very important issue. And I'd like to thank also all of those of you who tuned in for the inaugural podcast of FPRI's Center for the Study of Intelligence and Non-Traditional Warfare on this subject. We hope it has been interesting and enlightening for you. It has been for me, and we welcome you to view future podcasts as they come. This is Phil Wasielewski saying thank you and have a good day.
Thanks for joining us on this episode of Overheard. Be sure to subscribe on Apple Podcasts, Spotify, or wherever you get your podcasts, and don't forget to follow us on the site formerly known as Twitter at the handle @FPRI. Overheard is a podcast of the Foreign Policy Research Institute, a nonpartisan think tank in Philadelphia. For more information about this and other initiatives, be sure to visit us at fpri.org.